Hello everyone, this is Priyanka from CS Priyanka's Profession Classes. Welcome to my channel. Today I am here with a new video that is Sources of Law. Okay, this chapter is from the Jurisprudence. This chapter is there in CS Executive, CS Foundation and other professional also. And you can say for me this is very boring chapter for me. So I tried for you people to make it little easy. Okay, because this is one of the important chapter in law or in jurisprudence, you can say, because question comes from this chapter in examinations. So now you have to learn this chapter, and this chapter is too boring that you cannot remember normally if you read this any books and all. So I felt like let me try something like I think you will understand from my chart and all, and I will try to make it easier for you people. So let's see how you get it. Okay, so let me start with a new chapter, that is Sources of Law. This is from the Jurisprudence. And in case if you are having any query, you can write in my comment section after doing this full video. And in case if you like my video, please don't forget to like, share and subscribe. And also don't forget to share with your friends also, so that they also get chance to do this class. So let's get started. Okay. So today my topic is jurisprudence. Okay. Today my topic is jurisprudence. Now what do you mean by this term, that is jurisprudence? Jurisprudence actually means interpretation of law. What do you mean by interpretation? That means how you can say what is actually this law means. Okay. So interpretation means how you are interpreting law. Okay. So how you are interpreting law. So first let me give an example to you. Think this Amazon. What is Amazon? From where we do all the shoppings nowadays, online platform. Okay. We all have these apps in our phone. Now this Amazon, some people feels like what is Amazon? It's a shopping platform, right? Because we all have these apps in our phone, and we all love to shop, do the shopping from Amazon by going in these apps. For some people, those who started Amazon, for them it is nothing but a business, because they are doing business. For some people, for example, those who work in Amazon, like employees or delivery boy, for them it's a service work, or whatever they are getting money. For that money, they can have food. So this is a way of having food. Okay. So these are all interpretation from the perspective of the persons. Okay. So it actually varies from one person to another. This is, we called it interpretation, or you can say jurisprudence, what we mean. So we are actually interpreting the term Amazon. So Amazon means shopping platform for us, business or money from the perspective of the people who started Amazon. Those who work under Amazon, for them it's a money, service, salary, all these things. So we have interpreted in a different way. Same way, how you are interpreting this law. Got it? That is known as jurisprudence. Got it? So I need some more space to explain law. So let me explain in the next page. Now we are going to interpret what do you mean by law. What is law actually? See, if you hear this word or first after listening the word law, what comes to your mind? What is law? It may be a code. What do you mean by code? Rules or regulation. Okay. Secondly, you can say with punishment or without punishment also law is there. Law means what? If you violate the law, punishment will be there. If you don't violate the law, no punishment will be there. That is also one of the interpretation. Next, you can say, actually, the law, from where this law came. This law came from the term custom, custom. What does this custom means? Pratha. In Hindi, we called it, or you can say in English, system. So for example, like whenever these laws or acts were not there, but we were having the customs. You can take one example, like this marriage customs. Like we actually follow some customs while we are going to marry, right? So whenever we are following these customs, from here only they make the act and said in the Hindu Marriage Act, you have to do this. Got it? Actually, this from this custom only the law came. So this is also one of the interpretation of law where this law comes from the custom, pratha, system, whatever is going on or coming from the back from long time. Law also made, the person who made the law, they also kept those things in their mind. They taken all those things in the consideration. They made the law. Okay, so custom is also one of the important interpretation of law. So under customs, you can write one example, that is Hindu Marriage Act also. Sorry. Hindu Marriage Act also is based on custom also only. Next is precedent. What is precedent? Precedent means settled law. Okay. That means whatever is already there, we are following it. Got it? Settled law means it's already there. It's not in our hand. It's already, the act is already passed and already there. Everyone is following. So now law means we have to follow all the law, whatever is already settled. We have to follow those settled law, which is in one term means precedent. Got it? So by law also, by hearing this word law also, we can see, oh, this act is already there, we have to follow. You did the murder, you have to go to jail now. It means police will come and will arrest you. Okay. Oh, you violated the traffic rule, so you have to give the penalty. So these are all settled law. So this is known as, in one word, precedent. And one more interpretation is there. We will read about international law. Okay. So what is actually means international law means whatever it's a, like in our country. Okay, like whenever international law means whenever in our country is collaborating with the outside country and working on it or something, you are based on that law. So it's a system of treaties, you can say, that nations or governs how nations interact with other nations. That means international law means, for example, um, it is, you can say, some point you can remember how one nation will interact with other nation. Okay. And this interpretation is also different, like how one country is going to do business with other country. Okay. How one country going to do business with other country which is outside, with other country, okay, which is foreign one. So this interaction between two country will be regulated by the international law. Got it? So that's why law means also not only Indian law, you have to know about this one. Without knowing international law, the your nation people or one nation cannot interact with the other nation. So there are some rules here also, there also. Both the country, there are some rules. So one country, one nation, one country should interact as per rules and regulation with the other country. So these are the interpretation of law. Got it? So we are going to discuss today about these things. Jurisprudence, we called it in one word jurisprudence, which means interpretation of law, and now I interpreted in a chart. Okay, so you can write this one. Law means some, it can, law means some rules and regulations are there in law. We can, we knew it, like law means what? Law is imposing, means rules and regulation we have to follow. Law means punishment. If you violate the law, you have to, you will be punished with some fine or imprisonment, etc., etc. Okay. And if you don't violate, then no punishment will be there. Without punishment also, you have, sometimes we have to follow the law or rules. From where the law came? Law came from custom, that is pratha or system, whatever is coming from long time. Next is precedent, means whatever is already there, some settled law already there. Now what happened? Law means we have to follow those law or those act. And international law is necessary when one nation interact with other nation. They should know their custom, their system, how to interact with that country. In indirectly, you can say also, like when one country wants to do business with other country, they also should know the rules, terms and condition of their government and all. So this all about interpretation of law. Now we are going to discuss about some jurists and their point of view on this topic, that is interpretation of law. So how those jurists interpreted the term law, this is all about this chapter is. Okay. Now we are going to study some of the points of view of the jurist. Point of view of the jurist. Okay, from the perspective of American, historical, physiological, sociological. So this is very important. Like these are the jurists who has interpreted the term law. Okay. First point of view we are going to read about the American point of view. Who did it? Austin. Austin was a jurist. From the American's point of view, he has interpreted law. Next, historical. From historical point of view, there are jurists like Hugo, Maine. They interpreted law. Next is physiological. From the physiological point of view, there are jurists like Kant, Hand. etc. And finally, sociological. From sociological perspective, there is a jurist, Pound. So today we are going to read in detail about their point of view, like what Austin felt, what Hugo felt from the historical point of view, how they interpreted law, from physiological point of view, how Kant had interpreted the law, and from the sociological point of view, how the Pound interpreted the law. But out of all these things, the American is Austin, who interpreted law, and same time, whatever he has interpreted, this Austin, same time it was criticized by Salmond. So Austin has interpreted law from the American's point of view, at the same time it is criticized by the Salmond. That also we are going to study in this chapter. Okay. And also in a short, I want to tell you here, there are three sources of law. There are three sources of law. What are those? First is legislation. Second is customs. And third one is precedent. Now, what is legislation? What is legislature or legislation? Legislation means law making or lawmaker. We call this legislative assemblies make the law, and legislation means law making body or law making power. Okay, so there are three sources of law. The person who is making the law means how it is making, from there itself law is coming. So this is the first one, legislation. Okay, custom means, you know, it's I already said in Hindi we called it pratha, or is a system, okay, which is coming from a long time. Example like Hindu Marriage Act. Okay, so something is happening from a long years marriage acts, something is coming from a long time. So now what happened, that thing is only they are making the law by writing all those the old custom systems, whatever we were following before. My grandmothers, grandfathers were used to follow all those rules, systems. Those only coming inside this act and forming the act and forming law. Okay, so now it's became mandatory for the person to follow. So we called it custom. So this is also one law, like whatever pratha or whatever systems were there, from here itself they have taken those things and made the law. So one of the sources of law is customs. And precedent, I already said you, it's a settled law. Settled law means uh, like legislation means they're making the law. Na? Legislature, legislative assemblies are making the law. So whenever they're making the law and such law is going to be get passed, it's passed by the parliament, okay, or passed in the parliament, then those acts become enforceable. Okay, so enforcement, once those act becomes enforced, okay, or from that date means the passing date in the parliament, the next day onwards we all are going to follow such act. So same thing like this, legislation means whatever they are making the law, it needs to be passed by the parliament. Okay, and it is become a settled law. So once it is settled means it's already there law. So if we are doing that work, we have to follow this law. We have to do that work according to the law. For example, Indian Contract Act, Partnership Act. For example, we enter into a partnership means we have to follow the Partnership Act. We wants to open a company means we have to follow Companies Act. So already this act is settled. No need to change. We can't interpret nothing. Already it's there. Okay, so we have to only, the thing is we need to follow it and we need to perform. First we are going to see about Austin's point of view. Okay, so this is provision 1. We are going to read about the John Austin his theory of law, or else you can say John Austin's point of view. Okay, so how he interpreted law. Now if you're talking about, means these questions usually comes in the examination, like explain the theory of law of John Austin, or who means American, from the American points of view, explain the law. So then you have to write what John Austin, the jurist John Austin, explained, or what was his theory of law. So actually Austin's theory, if you asked, Austin's theory of law is, you can call it like imperative theory of law. Austin said, or Austin explained law in 3 words. First is command. He explained, or as per his theory, law is nothing but a command. Point number 2 is law is nothing but a political sovereign. And thirdly, law is nothing but a sanction. So Austin explained, as per Austin's theory of law, law means these 3 terms. What do you mean by command? Command means one, for example, there will be 2 persons. One is superior and others one is subordinates. For example, some persons are there in the superior at the top and subordinates are there. So for example, you and your boss, okay, higher authority or any other government regulator and the company, like that. So always superior will command the subordinates and subordinates is going to obey those command of the superior. So that is actually known as command. So law is also like that, na? Already there is a set law and they are just asking us, forcing us to follow those laws. Otherwise penalty or punishment is there. So that is a command. Okay, they are commanding us to follow the law. So that is, law is nothing but a command. What is political sovereign? What do you mean by the term sovereign? This means, political sovereign means law is a law because it is made by, law actually is made by the sovereign. What do you mean by the term sovereign? The term sovereign means superior. Just now what I said. So superior means who are sitting at the top. Okay. Now superior is going to control or give a command or direction to the society. And society is going to obey, okay, them. Now, as per law, the superior are sitting at the top. They are the head of the everything. They are going to give the direction, instruction to the society, and accordingly, society should follow that. But superior is not going to habitually, the superior does not habitually obeys others. Got it? So these are the who are sitting at the top habitually. They don't obey others. Got it? So this is the concept of sovereign. So sovereign means who is sitting at the top, or you can say head. Okay. So this is means the supreme one who are sitting at the tops, and their nature is to give the instruction, direction to their societies and the normal people, and we are forced and we are bound to follow them, to obey them. If we don't obey, okay, if we don't follow law, if the society violates law, if the society don't follow the obey of don't follow the instruction of the sovereign, if they violates law or directions, okay, or instructions of the sovereign, then what will happen? Happen sanction. What do you mean by this sanction? Sanction is nothing but a penalty, or you can say punishment. So basically, as per law, or Austin said that why we should follow law. Because we have to follow law out of fear, right? What fear? Fear is about sanction. What fear is there in us? Like if we don't follow law, if we don't follow the rules and regulation or whatever already is there, we will be penalized, or we have to pay the penalty, or we may suffer the punishment. We will be punishable under law. Got it? That's why we are bound to follow law. Now, that's why sanction is mandatory. Got it? Until and unless they give us punishment, the fear will not be there, and we won't follow the law. So, this also one of the thing to force us to follow. So, only for that sanction only we are going to follow the law. For example, if you think like we are driving car without license. So, this is actually violation of law. Got it? If no rules were there, if no motor vehicles rules are there, for example, like if no rules were there, that means what happened? That means you can drive without license. So no fear of punishment is there. So now act is there, existing. It's a precedent. Settled law is already there. So that's why out of fear you will carry the license. You will have license for driving and riding bike or scooty, bike, car and all, driving car or riding bike or scooty. So you will, means mandatorily you are concernedly you are going to have license before, means while you are driving or riding, because out of fear. Because if you are violate laws, or if you are violating laws, going to violate laws, then what happened? You may be punishable, or you have to pay the penalty for such violation. Got it? So that's why this is John Austin's theory of law. Austin explained law only by telling three words, that is command, political sovereign and sanction. Okay, so you can also write command is nothing but an order from the sovereign. If that order is not followed, accordingly sanction will be there. Got it? Now this is the continuation of the provision 1. Austin also Austin, as per Austin's theory, other than these three terms that is we have read just now, he explained law as command, that is order, of the political sovereign. Political sovereign means who is sitting at the top. Sovereign means superior. And if you don't follow the order of the sovereign, then there will be sanction. He explained law like this. Other than this, Austin also said that this three is nothing but coming under the DPSP. What is DPSP? Directives of principles, directive principles of state policy. Directive principles of state policy. So this is actually the topic of constitution. Those who have done constitution, they will understand better. Still, I will tell you, like directive principles of state policy is nothing but how state, this is a type of policy which is going to be followed by the state. That means these are the directions, okay, these are the directions followed by the state. And who gives, like there are, central government is there, under that state is there, okay. So the as per constitution you can say, like there is president, governor is there, okay. They are basically only have the signing authority. Under that the full parliament is there, parliament is the, we can call, they are having the law making power, so they, we can, means they will be coming under the legislation or legislative assembly. So full parliament is there, where means all the ministers, MLA, MPs are there, okay. Prime ministers, all ministers are there, who takes decision, who makes the law, who pass the law. Whatever happens in the parliament only, it happens in parliament. Now they fix, under that is there, central government is there. Central government means they follows the central rules, okay, and central rules is made in the parliament, and then they are used to give the direction to the respective states. Got it? So state also cannot fix the rules of their own, cannot fix the rules of their own. So they also need to follow the direction whatever is coming from the central, okay, central. So this is actually known as directive principles of state policy. And clearly you can understand that this is the coming under, this is a sovereign, because they are giving the direction and instruction to the state. So this is coming under the, under that subordinates. Got it? So this is nothing but a directive principles of state policy. Got it? Now think, there are a lot of states. I already said that one state means if one nation or the states want to interact with the other nation, they need to follow what? International law. Now Austin is also having some view on international law. Austin said about international law that international law is nothing but a right against self-incrimination. And this is coming under the Fundamental Rights 32. Okay. So this is the viewpoint of Austin, that international, you can say, like he said like that, the international law is also having one value. Like what is it? It is nothing but I'm exposing myself. It is a right against self-incrimination. How you are exposing? Like like this is once to accusation or charge of, to involve one person, means to involve one nation is going to be involved with the other nation. So this is the means for interaction or for better communication with a different country or different nation, you should obey the international law. Got it? So international law is also a type of this obey factor is coming, like you have to obey, because whenever your nation is going to interact with the other nation, obviously your, for example, think just I'm just giving one example. For example, India. Okay, so India is going to interact with any other country or other nation. In such cases, I said, whenever this nation is wants to interact or wants to do business with other nation, it is mandatorily they have to follow this international law. So in such cases, obviously this country will act as a sovereign and India is work as a subordinates, because for interacting with them also, India needs to follow their rules and regulation. So this is also, Austin also explained international law as a sovereign, because whenever we are going to interact with any internationally or with any foreign country, so they will act as a sovereign for us and we are bound to follow them. Got it? So he also said like constitution is nothing but a sovereign, because as per constitution only, uh, these as per constitution only, the sovereign is explained in constitution only, means one should follow the supreme or the superior one. Okay, this concept came from the constitution only. So these are the viewpoint of Austin. So what he said, provision 1 is telling Austin explained law in three terms. First is command, second one is political sovereign, and third one is sanction. Okay, command is order. You have to follow the order of the sovereign. If you don't follow, there will be punishment. He also explained international law also as sovereign, because when our nation or India wants to interact with the foreign country, then they also needs to obey the laws, international laws or rules and regulations. So in such situation also, international law will act as a sovereign for us. So this is nothing but a right against self-incrimination. Now we are going to discuss about like this Austin's theory of law got criticized by Salmond. Okay, let's explain in the next page. So Austin's theory of law has been criticized by Salmond. Okay, so now Austin's theory of law has been criticized, or critics, by Salmond. Now what he said, Salmond is having very much problem with the explanation whatever is given by the Austin. So he said something against those theory of law of Austin. First Salmond said, first point, it is our law, not the law. Got it? So the law was said by the Austin, and he criticized and said this is not the law, it will be our law. Got it? It's our law which is going to be. First he changed this from the, it's our. Okay. Secondly, Salman said, this law means whatever Austin was said, like it was a command, it's a political sovereign, and third one is sanction. He fully criticized and said that law is nothing but a diverse law. It's nothing but a diverse law. Second point is he criticized Austin's theory and said law is nothing but a diverse law, because diverse means, you know, it's a separation. It always separates us, okay, from the law. Got it? Law is something else and we are something else. So law actually forces us to follow that law. Otherwise punishment is there, but it is not like means he is against the explanation of the Austin. So whatever Austin's theory of law was there, it was criticized by Salvan. And secondly, he said, first of all, he said like it is our law, not the law. And secondly, he said law is nothing but it means a divorce law. Okay. Thirdly, he questioned about international law, because Austin said that international law is nothing but a sovereign for us. Sovereign means superior. He said how it will become sovereign? Why we should mandatorily follow them? We should not follow them, and always it's not necessary that it's not necessary for us to follow international law always. So it cannot be sovereign for us. So he questioned on this point. Thirdly, he also said Constitution, how the constitution becomes sovereign. He also questioned in these 2 points. After he is having so much problem, okay, with the theory of Austin, he questioned all these 4 points. Along with this, Salmond, as per Salmond actually, Salmond said about law that law is, or law means admin of justice. So as per Salmond, law means admin of justice. That means law is nothing but we only follow law to get something, some justice, okay, to us. Like he explained this law in 3 terms, that is, it is nothing but justice, moral and ethics. So we all know like as per Salmond, he's telling like we follow law, and with law we also visit court only for getting justice, nothing else. So law is nothing but we are actually one's justice. That's why we go always with law, or we follow law, or as per law we only want justice from that. Okay, who has done good, they should get justice. Who has not done good, they should get the punishment. So we always fond of this justice. Second is moral. Moral means your own, you can say, conscience, like what to do and what not to do. It's your own thing. So you should first you should believe like this is correct and this is not correct. I should not murder, this is a crime, criminal activity. So this type of things we called it, it's a conscience, moral. So law is also like that. And ethics means your moral behavior towards your society. So how you're going means behave towards your society. So that is law actually. So law actually regulates us and control us so that we maintain our decency, and we means like it's maintain our decency to sustain in a society in a peaceful manner. So to stay in a society in a peaceful manner, we should follow certain laws, and that is our moral behavior, how we will behave towards the society. That law is going to control us. So as per Salmon criticized Austin, totally criticized Austin, and he explained law as admin of justice, and he also explained that law is nothing but a justice, moral and ethics. So whenever you are asked to write about the Austin's theory of law, you have to write this full thing, like what Austin said about law, and along with that how what are the questions brought by the Salmond, like it is critics after doing the criticized Austin's theory of law got criticized by Salmond, and after criticizing those points what Salmond said, and as per Salmond what does this law means. Okay. So now we are going to discuss about some school as well as the analysis done by some analyst. Okay. So let us start with analytical school. Okay. So what is our subject? That is law, sources of law. That means if you ask like, you know, like law is written by someone, okay, that person is a human being. So now if I ask you like the person who has made the law, on what basis he made the law. So now this term law, we are just interpreting this law, got it, like whenever we are going to make this law, anything we referred, or whether how we have interpreted, how we made these law and all. So there are many jurist analysts, okay, who actually interpreted the law. So that's all about the matter in this chapter. So let us start with the analytical school. Analytical school, that means analysis, you can say. This is one school actually. This is started by Bentham. You can say Bentham Analytical School has paraphrased by Bentham. Means Bentham has started this school, but after that it is continued by Austin. It is actually paraphrased, means it started, you can say, beginning in 19th century. Okay. Now it is a lot of analysis done by the Austin, because about law, what is law, you can say. So how the Austin interpreted the term law. First of all, we will discuss about the analysis of this law by Austin. And this is actually, though this is under, they are coming under the school of analytical school, it started by Bentham but continued by the Austin, and here this, under this school only, Austin interpreted the law. So how the Austin analysis, or he has done the analysis of this term law. First of all, he is very positive in nature, first of all. So he always believed that as it exists currently, he don't believe in history, first of all. So he is very positive in nature as it exists. Second is, we call this school as English school, or you can say Austin school. And he don't believe in history. So that's why while analysis, he has done the analysis of the law, he has not referred also anything to history. So he has not referred any history, no reference to history was there. It means how it's developed and all. So he always focused only now. Okay, he always focused on now, which means he always means he, these people, means those who are coming under the analytical school or English school or Austin school, they were always living on the moment. Okay, on the moment. So just now we discussed in the last slide that this analytical school or American school or English school, Austin school, whatever you say, this Austin analyzes the law in a very positive way. Got it? So he believes only now, he is staying in the moment only. So he don't believe in history, or he whenever he is going to analyze the law, he don't refer any history or background, etc., etc. So Austin's analysis, you can say, Austin's analysis, you can say, is very accurate and logical. Okay, so I think you remember how he means explained the term law. He only, while explaining the term law or while interpreting the term law, he said three terms. That is, one is command. Command means order. We have to follow the order of the law. Whose order, who is sitting at the top, we called it them as sovereign. And if you don't follow, then obviously sanction will be there, which is known as punishment. So on the other hand, that's why Austin is known as father of English jurists. Okay, so Austin is known as father of English jurists. Now, we all knew, like, whatever Austin has explained, though he is a very positive person, though he has explained everything in a very positive manner, still it is criticized by Salmond. So guys, whenever you are going to write about Austin in examination, you have to write about this person also, that is Salmond. because without writing Salmond, obviously the marks will be deducted, because obviously whatever you are going to explain of Austin's theory, you have to say like this: his theory is specifically criticized by the jurist Salmond. Okay. And again, once more time, I would like to say like Salmond is having a problem, lot of problem in his explanation. Like this is just a revision that he said it is a law, because he said law is a, not da, because many laws are not there, only one, we have to follow it. It's a law, it's not a da law. This is first. Secondly, always Salmond focused on justice and Austin focused on now. That means whatever is happening present, at present, current. And he also said like law of imperfect obligations. He said like whatever Austin has said, that is like it's not fulfilled, it's a imperfect obligations. So he also said like laws of, he also said about this law of imperfect obligations. And lastly, he is also having a problem about international law, because Austin says that international law is also a law which we have to follow. Okay, so law is a, as per Salmond, international law is a modality but not a law. Got it? Because whenever we are following their law, so actually we have to pay whenever we are entering into another country or another nation, we have to follow their law very strictly. For that we have to, we pay for that, we take the receipt. So this is not a law, this is just a give and take. They are allowing us to enter into their country, and for that we have to follow certain rules and regulations. So this is like a, on the basis of morality is international law is coming. It's not completely a law as per means you can say Indian law. So these are the criticized or critics done by the Salmond against Austin's theory. Now we are going to discuss about the theory of heart. Okay. Last slide we did about the theory of Austin as well as the theory of Salmond. Now we are going to read about the theory of Hart. Hart is also an analyst as well as jurist. Now what he said about law, or what he said about the concept of law. See, first of all, you have to remember, by explaining the concept of law, by explaining the concept of law, he said two term or two word. He said first, he said law is nothing but a human behavior, and that also becomes non-optional. That means how you're going to behave, that is law. Whether your behavior is illegal or legal or valid or against society, that is a law, your behavior. And you have to behave nicely, you have to behave this way, that is also non-optional. So that is also not mandatory. Got it? So if you follow it, then fine, no punishment or no penalty will be there. If you don't follow it, then punishment is there as per law. But still, what is law? It's your behavior. If you are disciplined enough, if you are behaving properly, that is your behavior, and that is a law. From there itself, the law starts. And it is non-optional. That is not mandatory that you have to behave in a same manner or in a similar manner in every time, and like that. So that is also a non-optional. So According to Hurt, he is telling like being obliged versus having an obligation. So for example, it depends. Okay, if you are being obliged, that means your responsibility is to do such work. Then what you will do? So I can give you one example. That example is gunman. His duty is to hold the gun. So it is his duty to hold the gun, and that is also licensed gun. So for him, the law is telling and imposed on him that if he don't hold the gun, then he will be penalized. But think about for normal people like for us, we are not eligible to hold any gun. Okay, because it is not our duties or it's not our right to hold the gun. If we hold it, then we will be punished or we have to pay the penalty. So just opposite. So it depends on the obligation whether you are obliged to do it or not. If you are obliged to do that work, then fine, that is your law. And in my case, what happened? I'm not obliged to hold this thing. So this is my law. So both the law is different. So this is law is different from one person to another. So he explained specifically hard. First of all, you have to explain like he has said focused on these two words, that is a human behavior and non-optional as well as obliged. If the people are obliged to do so, that is law. For his means the law for his to hold the law means hold the gun. I'm giving just example. So his obligation is to hold the gun, but for other people it's not his obligation to hold the gun. So it's a differs from one person to another. As well as Hart is also explained law, and also he focused, said it's a habit as well as rule. Got it? So it's your habit, human habits as well as rule. That is actually the law. So as per Hart, if you are asked me in one line, then we can say like it's a rule of conduct, or you can say habit or human conduct, or you can say external conduct of an individual. External conduct of an individual. So Hart specifically focused on the rules, human behavior which is not mandatory, as well as the obligation, internal behavior, external behavior of an individual, it's a habit of an individual, conduct of an individual, all these things. Next we are going to discuss about the historical school. Okay. Historical school. So now we are going to discuss from the historical school's perspective what do you mean by law and how the historical schools interpreted the term law. So you know from the term itself historical, they always believe in the background or the history or the past. Got it? So I can give you one example like they depends on the past. Got it? There are stages and development. That means last, for example, like after, before last 20-30 years or 100 years, before 100 years, like what happened. On the basis of that, they have interpreted and made some renovation and created law. Got it? This is a positive. Sometimes they made the positive, sometimes they made the negative. Again, sometimes they made the positive. So it's a combination of positive and negative law. It's a stages and development. And in one, whenever you are standing in this stage, Whenever you are preparing the law, you are referring the one. Okay, referring the past years, what you did, what the means, what are the renovations, what are the extra needs to be added, what are needs to be deducted, etc., etc. On the basis of that, you will prepare this. Again, whenever you are standing in third stage, you are just referring the second stage and making the law for the third stage. Again, whenever you are standing in the fourth stage, you are referring the third stage law and you are preparing for it. So historical means always we depends whenever we make the law or whenever we are interpreting the law, when we always refer the history as well as what happened in the past, what are the loopholes were there in the past, what can we do for doing it better. So this is actually historical school. So they always do the analysis, they always do the R&D, that is research and development. So that is historical. So they always, those who are there under the historical school, they are always searching for thread that is common. Got it? So whatever law was there in all these stages, we always search for the what is common in all these four. So always we will find or we will search for the threads, whatever is common in everywhere. Got it? So actually we also called it as natural school of law. We also called it as natural school of law. Natural school of law said that law is same. Whatever you make it, it is law. Okay. So whatever law you make it, law is same. Got it? And you also said that law never changes. So natural school of law, law is same and law never changes. Who said it? Remember, Montesquieu. Okay, remember this name, very important name, you may get in MCQ as well as in question. Montesquieu is a person, we called him as a first jurist. Got it? He said this term. Under natural school of law, Montesquieu is the first jurist who said law is same and law never changes. Okay, because they always, though they are under the historical school, they always in a search of history of law. These people, these jurists under natural school of law, they always trying to search. Okay, they always trying to find out the history of law. That's why they always say like all laws are same and they never changes. Who said this is Montesquieu, who is the first jurist of this school. Okay. Now Hugo. Hugo is also a jurist. He said law is nothing but a language as well as a manners. Because you know, like only in our society or in our country law is there, that's why we are behaving so disciplined way, because we knew it, it is there in our mind that if we don't follow the rule we will be penalized, or we will be like we are violating. If we violate the rules we will be penalized, we will be punishable, okay, under these act, under these sections, etc., etc. So we these law actually teaches us the manners. Got it? And also you know the legal languages are also different, so it's not like our local language means normal English language or any other language. So this language matters as well as this teaches us manners. So law, as per Hugo, it is law is something which is actually a language as well as manners. So under historical, what we come to know, it is also known as natural school of law. Those who are there in historical school, they always try to refer the history as well as past, and they also always try to find out the history of law. Because in every stages they refer the past as well as they always try to find out something common from every stages. Okay, there is one first jurist, means there's one jurist, that is Montesquieu, who we will call him as a first jurist, and he only said under natural school of law that law is the same and law never changes. Got it? But Hugo is there. Hugo is also a jurist. He also said that he said something different. He said law is nothing but a language as well as manners, because uh, though law is something where means though law is there, that's why we are following these and we are disciplined enough. So this is a different language we known as a legal language, and it's a language as well as it teaches us the human beings manners. Now we are going to read about another person, that is Egg von Savigny. Okay, now there is a person whose name is like von Savigny, we called it like FK von Savigny. He has written a lot of books. Got it? We called it, he means von Savigny is a person who is known as the founder of historical school. Got it? Just now we have read na historical school. So sorry. So just now we have read about the historical school and the first jurist Montesquieu, Hugo as well. But who started this historical school? The founder of historical school is F.K. von Savigny. Now he has written lot of he's having means he has written lot of books. Got it? If you search the books, for example, like the history of Roman law in the Middle Ages, as well as the law of possession, lot of books he has written. He said actually that what is law? He said like reflection of the spirit, reflection of the spirit of people who evolved it. That is law. Got it? So he actually focused on the spirit of people, spirit. Okay, so it's our reflection, our spirit's reflection, that is law. How, who, what is law actually? Whether we will follow the law or not, it is depends on our morality or our ethics you can say. So whether we will follow, it's our conscience, right? It's a spirit. He just explained like it's a spirit of ours, and if we, the reflection of the spirit of ours means the people, whatever is evolving, that is known as law. So he actually focused on the spirit of people, this term. This is first point one. Secondly, he is completely against this natural law. Natural law we have read at first, like whatever is that Bentham, Austin. Okay, oh sorry, no, against the natural law. Natural law is the historical. Just now we have read in the last slide. Natural school of law, where it is said like law is same, as well as law never changes. That's one. So it's not all about Austin and all. That was different. That is analytical. I just got confused. Sorry. So first of all, he focused on the spirit of people. Okay. So our spirit, it whenever it evolves, that is law. That is our manners, disciplined as well as conscience, all those things. He is completely against this natural law, that is whatever we have read just now, that as per natural law school they were always trying to find out something which is common, as well as the Montesquieu, who is the first jurist of the under this natural school of law, he also said that law never changes, it is same. So he's against this. Got it? And Volks was there, Volks, just. He also said, this person, this or he also said that law is nothing but a national spirit, as well as genius of the people. So he simply explained uh, law as the national spirit, like he actually thought means he actually interpreted in a global manner, like national spirit, as well as it's a genius of the people, like how we think, what is wrong, what is right, okay, our thoughts. If we are genius enough, that is law. So if you are not, then we have to follow the sanction. That means we will be punishable, okay. But however, or if we are genius enough, how we thoughts, how if we can think or we can interpret like what is right, what is wrong, that is law. So as per Vogt, law is nothing but a national spirit as well as genius of people. As per von Savigny, who is von Savigny? He's a founder of historical school. He also focused on the spirit of the people. It's a reflection of the spirit of the people, and he's totally against this natural law. That means whatever is said under the natural law, that law is same and law never changes. So he don't agree with these. Got it? If you ask me what is law actually, lot of jurists has said many things about law, but actually law came from custom. You know what is custom? In Hindi we called it pratha. Got it? So custom is actually the main sources of law. We called it. Got it? So we already said, like, so yeah, under sources of law, in the next after this we are going to explain the sources of law, and also the theory of law, Kelson, and sources of law we will explain. So there you will come to know, like, there are three sources we called it, like custom is the main source we called it. After that, precedes is there, okay, legislation is there. Got it. So precise means a settled law, whatever we are following, as well as legislation, the lawmaking body or lawmaker. But from where this law they're making, means from what they are referring, actually nothing but a custom. Whatever is coming from the last ancient times, what are the rituals like Hindu marriages, systems and all. So from there only they are preparing the law. So law is nothing, but you have to think, like, there are many things like nation. Whenever you are making the law, you have to keep in your mind about the nation, your, or for example, like organizations, born or birth, matures, whenever you're growing stage, as well as your death or dies, whenever we die. So if you think, whenever you are preparing the law, legislative body is preparing the law, like they have to think about this nation, organization, born, matures, dies. This is law is nothing but a part of a means part of our system, or you can say part of our organization, organism, you can say. So law is a part of our life. Got it? So law is a part of our life. So first of all, we can say, like, out of all these things, custom is the main thing, main sources from where law is coming, because custom came first. After that, after following this custom, the law is made. So indirectly law is coming after following these customs only. So that's why we can treat this custom as a main source of law. Okay. Now, next topic is pure theory of law. On the other hand, we also called it as Kelsen law, Kelsen theory of law also. So we also call pure theory of law, or we can also call it like Kelsen theory of law. So let us discuss about this. Kelsen is a person actually, Hans Kelsen, who actually explained this theory. We called it as pure theory. So anyone, they can ask it. So same thing. So let us understand what is this pure theory of law. Got it. Now, before this slides, before this slide, we have read about Austin. We have read about Analytical School as well as Historical School, what they said. We have read about Hart. Okay, we have read about Savigny, Volgist. So we have read the theory of these jurists. Got it. Whatever they have said, pure theory, what they did, they some just filtered. They just this Hans Kelsen actually, whenever he made this pure theory of law, this under pure, they have just filtered their explanation and interpretation, and he made his own theory. Got it? So he filtered their theory and made something new. As well as this under pure, deducted something from their um, explanation or analysis. What deduction he has done? First, he has deducted the word ethics. Then he has deducted the word politics. Then he has deducted the term history, as well as he has also deducted the term sociology. So whatever we mean, sociology is all about the society, your behavior towards your society, your own manners, this human behavior, all these things. So he has completely deducted these things, ethics, politics, history, sociology, from their expressions or their interpretation or analysis of law. He made something refined analysis. We called it like refined analytical. So who made this pure theory of law? Just remember the name, Hans Kelsen. Very important. So who made this pure theory of law? Hans Kelsen. Got it? So Hans Kelsen, he said like uniform. Okay. Hans Kelsen said that uniform, applicable at all times. Got it? So just I'm explaining by giving example. For example, school. Whenever we are going to any school, how we will feel that this is a school and something different from our house, different from our mother's, father's. This teacher is different. We have to follow the rule. We have to enter the school on time. We have to come out at time. We have to eat lunch at time. How? Because as a school, we are having uniform. Okay, they are having separate rules. We have to follow the rules. So, and if they also behave like our house people, like our people, means mother, father, and relatives, then we can't feel that that is also school. Got it? So how you are going to make it differ? So that's why uniform is applicable at all times, to make you feel that this is law and that is separate from you. He also said that as law is actually laid down, is actually laid down, not what is ought to be. That means whatever is written, you have to follow. You cannot make it of your own. Got it? So law is something which you cannot make it of your own, but whatever is already laid down, you have to follow it. That is law. And to follow it, you should have the knowledge of law. Knowledge of law, or we can also call it knowledge of norms, because norms is the other term of law, rules, regulation, all these things. Continuation. So Hans Kelsen said that law is something which which is there. We have to follow it. Means already it is there and we are following it, and we cannot make it of our own. Okay, law is not something like that we are making it of our own. Okay, so for law is something which we should have, that is the knowledge. So knowledge of law. We can also say it's a knowledge of norms. Norms means rules or regulation. Got it? So on the other hand, we can also call it, like he explained about the grant norms. This is a very important term, grant norms. He said something about this grant norms. First is, may not be same, but has to exist. Second, series of odds. For example, like if X happens, Y takes place, like this type of things. And third is justification of the entire legal system. Got it? So grant norms is something which may not be same. That means some rules may be, some rules for me, and that rules may not be same for you. So law may be differ from one person to another. So if I am violating one rule, so I have violated one separate law, that's why I will be punishable for that law. Obviously you have not violated, so obviously that law is not applicable on you. So something you have violated something different law, so obviously the law is differ from one person to another, it's different. Okay, so some law is imposed on some penalty, or some law is applicable for me and that may not be applicable for you. That is, we called it like may not be the same for all but has to exist. Okay, the law whatever is applicable for me, it should not be something abnormal which does not exist, like that it should not be like that. So it already exists and it is applicable on me, then that is also we have to follow that norms. This grant norms is also can be a series of ought, that if you do this then that takes place. For example, I can say if you ride your bike without license, then you will be punishable, obviously. Got it? Because you are violating the rules. If you are violating the traffic rules, you have to pay the penalty. Okay. If you want to drive, you should have DL. So if it X happens, then Y takes place, like this type of thing. So all this is a series of OR. So for one, so all are linked. Got it? So these are also rules. So you, for driving a car, you should have DL. This is a linked thing. And grant norms or rules or regulations are such things as a justification of entire legal system. So if you do the wrong thing, if you violate the law, you have to pay the penalty or you will be punishable. If you don't don't violate it, then okay, it's a very smooth one. You are not going to be penalized or punished. Got it? So it says justification. So the person who are the wrongdoer, they will be punished. The person who are not the wrongdoer, they won't be punished. So this is justification of entire legal system. That is actually, these three are coming under the grant norms. So some conclusions are there. So let me explain here only in the same slide. So what are those conclusions? First conclusion, so you can write the heading conclusion. First conclusion is public law plus private law must be one. That means no distinction should be there between private law versus public law. Got it? See, if you do a wrong, then also you are a wrongdoer, you are a criminal, and you should have followed the law. And if you are in a public, we can say public, like many people, that also if they do a wrong, that is also a wrong crime, and they should also be should have been follow the law, and otherwise they also need to pay the fine, or they will be punished. Got it? So first conclusion is public law plus private law must be one, and no distinction should be there. Second point is natural person. Who are natural person? Like us. Okay, we are the individual natural person. And the juristic person. Who are the juristic person? Juristic person means, you can say, the person who are jurist. Okay, you can say the jurist, or the person who are controlling these rules and regulations. These are the person. So those who are natural person, or those who are there under the legal person entity, like any organization, or you can say human legal entity means like Supreme Court, High Court, those who are working in a parliament, those who can known as a juristic person. Okay, those who are means directly linked with the legal matters. So either it is a natural person or juristic person, JURISTIC. So juristic person, no distinction should be made. Got it? So that is also, you have to means if natural person or juristic person, that is also you have to treat them equally. If they both do anything wrong, then both of them will be treated same way. So no distinction. Got it? Got it? So first you have to remember private law or public law must be one, no distinction. Next is natural person or juristic person, whoever it is. That means legal or non-legal, whoever it is, no distinction should be there. Next is state should follow the system of human behavior. And of last is limitations. Limitation is there for us, that is international law. Lot of contradictions are there about regarding this, so like Austin. So these are the four conclusions under this Hans Kelsen has said under pure theory of law. Got it? He explained these grant norms, as well as the conclusion is like, as per Hans Kelsen, private law, public law must be one, natural person, juristic person, no distinction should be made. States should follow the system of human behavior, as well as there must be a limitation for the international law, like Austin. Whatever Austin said, you have to follow that. So finally, requesting you to draw a chart with me. Got it? For your clear understanding purpose, draw a chart, sources of law. So whatever needs to be understand, or whatever you need to write, okay, in the examination hall. Like in maximum time, the examination the question will be like explain the Austin's theory, or explain the Kelson's theory, or pure theory, what Hart says. As per Hart, what do you mean by law, or vogue gist? All this type of question you're going to get. So basic concept should be clear from the last slides only, but this I'm going to give this chart just for your clear view, like what is what actually. So who actually what is or how the sources of law has been distributed, or sources of law out of three types you can say. Sources of law, first is, we have already discussed, or we have already read, like how the Austin analysis, it means Austin has done the analysis of the term law, from where this law came, or about the sources of law. So as per Austin, so we have already came to know, like he defined about the sovereign, that means supreme or the superior people who is giving the order or command. We have to follow that order or command, otherwise there will be a sanction. That means we have to pay the fine or penalty, or we should be punishable by law and all. Secondly, sociological, or many sources we already have read. Sociological is like society, from the perspective of the society. There are many sources. We will discuss, keep it here like this. And last one is natural school. We have read about the natural school of law, as per that Montesquieu and all, that is divine. That means as per them, as per natural school, law is same and they never changes and all. It's a divine in nature. So let us discuss about the sociological way, that means in a moral or ethics. There are many sources are there. Here Salmond explained in a sociological way. He said, as per sociological way, the sources of law are of two types. One is formal, other one is material. Formal means, like it's a very formal and official. That means it is done as per wish of the state exist. Got it. So whatever the state feels that what is good for the society, or for the good for this city, as per that the law means law will be prepared by the legislative assembly. So that is formal in nature, wish of the state exist. And material are of two types. Material are of two types. One is historical, whatever we have already read in the last slides, and other one is legal. As per legal also we have read that sources of law are three, there are three types are there, from where the main sources of law are of three types as per legal perspective. First of one is legislation, precedent, and last one is custom. So I already said that custom is the main sources of law. So legislation is nothing but an act, or you can write rule of law for subsequent decision. Got it? So legislation is nothing but an act from which is made by the legislative assembly, and we are going to follow it. That's all. Precedent means we knew it, like which is settled law. Whatever is already there, we have to follow settled law. And custom means the oldest sources. It's the oldest pratha, or already it's a system coming from a long years, and now we are following it. Got it? Just note it down. I'm going to the next slide. we already discussed, like as per Salmon always focused on the justice. Okay, he also already means he already said, like he criticized Austin and said like law is nothing but justice. You have to think about the justice law. Uh, so let us discuss about the natural justice. You know what is law actually? Why we means prefer this legal things, like why we go to courts and all for getting the justice. So say it like law shall be known before it is enforced. Got it? So a very good example is like that. Whenever you are driving a car, you should know the law. Then only you should sit into your car. Got it? Get into your car and you should start. But you don't know any law of Motor Vehicles Act and you are just simply driving without driving license and all. So obviously the penalty will be imposed on you and you may have met an accident, right? So you should know the law before you're going to apply that. Got it? So you should have the knowledge of law first. After that, you are going to um, apply that law on anywhere. Got it? Second, you have to remember that morality of court is always greater than state. That means whatever state will decide about the law, etc., etc., if court decides something, then that is always greater than state. So court's decision can override the state decision. Got it? So it is very flexible and it's not rigid in nature. So you can change it. So whatever court feels it, or court can change the decision of the states. So always the morality of the court always overrides state's order or state's decision, and it is always greater than state's decision. Now, custom, it's a pratha or system of the society, how your society follows their rituals and all law. And you can also say the law of the state. In which state we are staying, we usually follow the law of that state. So let us discuss. So just draw a chart. This custom and society are of two types. How many types of customs are there? One is legal, other one is conventional. Legal are of two types. One is, you can say, local. Okay, in legal sense, how many customs are there? You can say local custom is there. That means in your area only, or in only your caste follows that system. Okay, only in your caste you do some specific puja, not all other castes. So this is your local specific things. We can call it a local custom or specific customs. Other one is a general or in a whole, like everyone follows it. Got it. Generally, your state follows that holiday or follows that rituals or do that rituals, etc., etc. And conventional means some tribes are there. Okay, some tribes are there. They are having their own custom. Okay, their own customs or own conventional system. So conventional is like that. So that means whoever is there in a society, everyone, we don't follow one system, but some tribes are there, specifically they only follow that system. That type of customs are known as conventional. Got it? And this general and whole, usually everyone follows, so there should be a no conflict and all. So this is the distribution, or you can say the types of custom. So thank you guys. I hope you will be benefited from this video. Means I will request you, please do it till end, otherwise it's very hard for you to understand, because I have explained one to one, and this is enough for your sources of law to write in your examination. So please don't forget to like, share and subscribe my channel. Thanks. See you soon.